Good afternoon, ladies and gentlemen. Welcome back. Our third session will focus on intellectual property, which is a very, very important and hot topic in relation to the regulation of generative AI. And as you probably have heard, there is a recent Chinese court decision, actually from the Beijing Internet Court, that recognized the copyright of an AI generative image. There are a bunch of very controversial topics that we will explore in today's panel, and I'm extremely pleased that we have 4 distinguished guest speakers that will join us today. 首先呢，我们有张平老师他是北京大学法学院的教授粤港澳大湾区知识产权发展研究院的执行院长，同时呢也担任中国科技技术法学会常务副会长，还有秘书长等多个学术职位张平老师应该是在这知识产权界就算是泰斗的人物我们是女泰斗然后呢是何晶，他是己任律师事务所的合伙人我们20年前就认识了就在何老师何律师的手下曾经工作过，就我前老板
张老师的
拥有20多年的知产的诉讼经验。当时我认识你的时候，你已经资深律师了呀。对，因为我大学毕业的第一份工作是在Baker然后呢，当时何律师已经是很资深的这个知产的律师了然后现在呢，他自己创业，然后开了这个新的律所，好像也做得特别好，所以非常高兴你今天能来。然后坐到我最左边的呢，今天我们的 panel 这个 panel 有3个3位杰出的女性是杨长华现在是微软大中华区的公共和法律事务部的总法律顾问，我们平时是叫她 Winnie 她是我们港大毕业的毕业生，刚才还在楼下看到了你的照片，待会儿大家可以参观一下就在拐角那，就是在1楼拐角那有一张照片几个人能不能认出来谁是 Winnie？ 那是多少年前 Winnie？ 能不能透露？记不起来了。And then on my immediate left is Professor William Fisher, who's the WilmerHale Professor of Intellectual Property Law at Harvard Law School, and the Faculty Director of the Berkman Klein Center for Internet and Society. I heard a lot about the Berkman Klein Center. You guys are doing a great job. In fact, we copy a lot of what you did for our center, Is that a violation of IP?
Absolutely.
Okay, let's start our panel today. 首先第一个问题想问问张平老师吧，先给我们一个概括，就是说在生成式人工智能方面遇到的这个知识产权的问题您在尤其研究实务中遇到什么样子的问题？
好，谢谢主持人。笼统的说，生成式人工智能遇到的知识产权问题其实是非常广泛的，包括著作权、专利权的问题。但是呢，我想今天在这里面，我们大家可能更多的是聚焦的是著作权的问题。那如果说著作权的问题呢，它分成2个方面，一个是说生成式人工智能在研发阶段，它涉及到的著作权的授权问题。另外一个是生成式的人工智能在应用过程当中，它产生的新作品的确权问题。所以这是2个方面。然后我们上午的这个讨论的过程当中，都提到了训练数据的合法性，提到了这个语料在学习过程当中它的原始数据的这个来源的一个合法。其中呢，最重要的呢就是知识产权的合法，就是著作权的合法。当然可能还有像隐私和个人信息的这种合法。那么在事先的著作权的授权合法的这一块又分成2个方面的问题，一个是技术性的数据，一个是学习性的数据。那技术性的数据呢，涉及到的是大模型、算法、软件它的这种数据的来源，它的合法性。比如说像在中国，在大模型的这个建设过程当中，它都用到的是开源社区的这样一些模型和算法。那么这个里面呢，就出现了你的技术的数据来源是不是处理好知识产权的问题了。尽管大家都认为开源社区里边的知识产权 它很简单，其实我个人的观点认为它是更复杂，它比闭源里面的知识产权的问题会更多。那因为今天的时间关系，我不再去展开，然后我们来去说学习性数据的合法性。那么学习性数据的合法性呢，实际上就是刚上半场我们讲到的，你要学习的更加客观的数据，更加科学的数据，更加准确的数据，还有多样性的数据，你一定会使用很多在先的这样一些有作品性的资料。所以这种学习性的数据呢，现在是制约现在生成式人工智能它的这个研发和它发展和它使用的合法性的一个障碍。也就是不论是在美国还在其他国家，在中国都存在这些训练型的数据的合法性的问题，包括上午说到的生成式人工智能的管理暂行办法里边的第7条明确的就讲到了，必须要尊重他人的知识产权，必须要保证数据来源的合法性。那么这一点就任何一个生成式人工智能的开发者都做不到的，就是全世界没有一家能够做得到100%的能够获得一个合法的著作权的授权，所以这是一个问题，就是一个关键问题。那第二个方面的问题呢，就是事后的生成式的这个人工智能它的产生物，它的著作权的确权问题，也就是它的生成物是不是能够构成作品，那么是不是能够受到著作权法的保护？那我想可能世界各国在这个领域里边也没有一个统一的认识。当然了，大陆呢，在上个星期吧，就是刚刚有一个判决，刚做下来。那么在这个判决之前，曾经也有过2大类的判决，一类认定是没有作品性的，就是生成式的人工智能做出来的是没有作品性的；一类呢，判决书认为是有作品性的。但是我们上个星期做出来的这个呢，是认为是有作品性的，而且是进一步的呢，从法理上做了一些阐述。那么未来可能我们说在中国就会有大量的涉及到生成式人工智能的这个确权和侵权的这个问题的这样案件。所以我就是说，先说这2大方面的问题，就是刚刚主持人问遇到了什么问题，那么一会儿有时间我们再去继续讨论。
张老师的这个时间掌控特别好啊，给了我们一个很大的框架。然后呢，我们接着呢会继续的，就是仔细的去讨论这2个大的问题。然后呢，下一个问题呢，我想问一下何晶啊，我记得这个生成式人工智能的这个服务的暂行办法里面也有提到，对于这个技术知识产权方面有提出的具体的要求，但是非常的笼统，好像就是说基本上就是说你做这个事情你不能够违反知识产权，没有什么具体的一些要求。我不知道我的理解是不是对的。那你在比如说企业合规，包括您在那个就是给企业就是说咨询的时候，您是怎么去处理这个？
谢谢胡月。关于知识产权尤其涉及到生成式 AI 这个管理暂行办法其实这里头尤其对于需要使用内容和使用 IP 的这个企业，应该是有宽松的空间会大很多。如果你现在看这个暂行办法，就像 Angela 所讲的，上面写要尊重知识产权，对吧？一旦你的一些法律都写尊重，你就不知道到底是什么意思了，对吧？尊重，后面还有一个更有意思，它叫涉及知识产权的，不得侵害他人依法享有的知识产权。我们中国的法律里头你一旦看到依法2个字你千万不要以为它只是放在那儿的，对不对？叫依法你要依法，你不享有这个知识产权，你有这个知识产权，你肯定也不一定能保护得了。所以在这里面更重要的是，你要去看到这个暂行办法的这个当时征求意见稿。那个我当时暂行办法出来之后没多久，征求意见稿出来没多久，我记得跟张平老师我们在一起正好来吃饭张平老师当时说何金，他说你相信吗？那上头那个征求意见稿怎么说的吗？你还记不记得？他说当时那个征求意见稿里说，用生成式人工智能产品训练的时候，应满足一个要求，不含有侵犯知识产权的内容，不含有，就很明确的叫不含有。后面还有一条是前面还有一个叫不能侵犯知识产权，所以当时的征求意见稿应该是非常强的，而且其实并不是特别现实。 所以有意思的事情是我们看到最后的稿件里头，它叫做不得依法享有，就是不能侵犯叫依法享有的。所以对实践当中，我想是什么个意思呢？首先，对吧？各个企业都要尊重知识产权，我想这大家都没什么问题，这是个主观的尊重。现实当中，我觉得未来的话，就像我们已经看到了，也像张老师所讲的，未来我觉得在中国的法院在整个的生成式 AI 的服务当中涉及到的知识产权保护会发挥很重要的作用。我们中国的这个法院其实也是一直非常活跃，而且一直都在找最好最新的案子最近已经出来这些最新的案子已经在开始表态了，但我们还要去介绍。然后我们的法官其实是非常有创意和创新的。就我自己个人觉得，我们的法官们应该都出现在这儿，所以 Angela， 你以后都请我们的法官们下次到这儿来讲讲我们中国的这些最新的判决，这样让企业
请啊。
好吧，我就先说到这儿吧。
行，那我先接着再问一下张老师吧，因为刚才你也给我们一个概括嘛，然后你也提到了，就是说生成式人工智能它在训练的时候可能会有涉及到很多的受版权保护的作品或者是它可能训练的时候它都不知道哪些是有版权保护，哪些没有，它都一揽子的放进去了。那在中国法之下，就是说我们有没有一些豁免的理由让这些公司使用这些那个有受版权保护的内容？那到现在为止，有没有一些相关的诉讼，或者是比如说行政的这些去干预？
实际上是这样的训练数据它不可能避免去学习有作品性的这些资料。比如说我们看到就是全世界最聪明的这些人工智能的这些产品，它一定要去学最优秀的一些科学论文呢，经典的这样的一些文学作品呢，还有音乐呀、视频呢、图片呢，它学习这些东西的时候，它一定是要经过别人的著作权的授权的。因为我们现在世界上的各个国家基本上保护水平是相当的，就是要在先获得授权，就连美国也解决不了这个问题。所以中国的很多的这种开发者呢，他一定是要去学习别人最优秀的作品。我们就说白了，就是那些科学期刊、文学期刊他们一定要去学习的。这个我们文心一言在这个办法一颁布出来，立即就跟我来去说，我们现在就想跟这个科学期刊、跟出版社去谈授权。要不谈授权的话，他就自己就看起来形式上就不合规了至少他还是努力去一家一家谈了很多出版社和杂志社，他都谈下来了。但是这就说明什么问题呢？这说明我们要想做一个非常客观的、准确的表达的这个人类智慧的这种生成式人工智能，你肯定是要学习人类最优秀的那批作品，所以避免不了。那么避免不了的时候怎么办呢？我想这些企业可能都是仅仅去寻找一些权益解决之计，就是在现行法律框架之下，比如说我能获得的这种通过爬虫协议获得合法的这种抓取的这种资料，那我就抓取了一部分。当然有人来说不让我抓，我就不抓了，这只能解决一部分问题。另外一个呢，去跟著作权集体管理机构获得授权，比如说你跟文著协、跟音著协。跟摄影家这个协会去谈授权，那你也只能解决那一个领域里边的一部分的授权。那因为集体管理机构它是个会员制，它并不是一个社会上普遍大众都参加的一个机构。那么还有一部分是什么呢？它可以去抓取一些开源的资源，就是开放性的社区里边，它也有一些没有著作权或者是著作权授权比较清晰的，比如说你到维基百科上去抓取一些资料，那个上面呢，它的著作权已经解决了。那么除此之外，还有每天每时每刻都产生的这些作品，它没有办法去获得实权授权。所以呢，有人就去想，那么在现行法律框架之下，没办法去解决授权的时候，能不能有些突破呢？刚才这个主持人说，中国法下有没有突破？中国法下没有突破，著作权里的合理使用不会给生成式人工智能的开发商和他的数据处理商和他的使用者说视为它是一种合理使用的主体，它不存在那13种情况。那么即使是在美国法下边呢，美国法下的合理使用有4要素原则，但是那个生成式人工智能也不符合美国法下边的合理使用的这种情况，除非美国的法院的法官能够在判例当中再增加出来像所谓的这个转用性的使用的这种解释。 比如说谷歌当年数字图书馆，他在去用别人的那一段代码的时候，本来是这个谷歌就认为这是没有著作权的。然后呢，后来呢，法官认为是有著作权的，但是呢，谷歌是属于合理使用，但是它是用了另外一种解释方法，是把法律重新做了一个解释。所以我们说，全世界的著作权在国际公约的框架下，在各个国家的法律框架下都没有给它一个例外的规定。中国当然，中国法也没有。那现在有人去提议说，如果在合理使用里面有法定许可里面也没有这种这个空间，可不可以从安全港的这个角度来考虑一下？比如说，互联网服务商在这个使用到他人作品的时候，不是自己主动的来去做事，而其他的自助上去的比如说像搜索引擎，它使用到别人的内容作品的时候，可不可以给他一个安全港的责任呢？让他能够发展下去。这是互联网早期的时候，我们世界各个国家都在想到的一个解决方案。但到今天呢，我们看到其实这个趋势也不是特别有利于生成式的人工智能的这个服务商，因为 CPTPP 的这个国际协定这区域这个协定，它里边呢就要求把安全港的适用的对象和适用的场景再进一步的去缩减当然美国可能退出去了，中国现在在申请加入，还没有进去。不过呢，它现行的这种规定就是安全港要慎重使用，所以我们也看到，如果中国的这些企业想推动政府在立法上说能不能通过安全港再给我一点免责，这个可能也是值得这个商量的就是很难去推动。那么再有，我们现在这个生成式人工智能，它就直接是一个内容服务商，它并不是一个互联网平台服务商，也不是个搜索引擎，它是内容服务商，它直接是把别人内容抓过来，我要去学习的。所以对于内容服务商呢，即使是在现行的安全港责任里，也不会给它扩展到那里面去。所以呢，我们其实尝试做了很多法律上能不能够解释的这样的一种空间，就是在法律不修订的时候，我们能把它解释进去。那看来目前其实是很困难。所以呢，最近呢，我们才看到美国的微软他们想出了一个新的办法，一会儿我们的下一位发言人可能会去讲，因为我刚才沟通的时候我们提到这一点，就是它 OpenAI 为了能够让它的这个模型能够继续下去，能让它这个生成式人工智能产品能够顺利的走下去，不被那些著作权所阻击的话，他就说了，如果未来有人在我的客户当中里边或我的这个企业当中来去主张说你们都是侵权的，那么 OpenAI 愿意给他们支付法律的费用。这就是什么呢？这就是一种著作权的一个保险的一个思路。就是说我总要有一种机构站出来，我就要是为这样的事情来买单，反正是挡不住你们诉讼，挡不住你们维权，但是呢，不会是全社会的所有的著作权人都来维权。那么在少量维权的情况下，法院不得不判侵权的情况下，有人来出来为这个买单，才能让这个产品和这个事业走下去。
张老师，我想借您刚才的这个发言再推入一下，您认为在现有的这个法律框架之下很难，就是说justify 它是合理使用，对吧？那您觉得修法的可能性有多大？
因为中国的这个著作权法刚刚也修过，是针对中美经贸协定之后，为了符合这个协定的要求，已经修过一次了。如果是针对人工智能再去进行这个修法呢，我个人其实认为不太可取。因为什么呢？人工智能整个这个事情的发展还是刚刚起步，法律呢也没有必要立即就去进行调整。那么在这个过程当中呢，我认为司法这个层面上呢，可以呢宽松一些，就是法院呢在认定这一类的侵权的情况之下，可以更多的去适用天平原则，就不要去适用惩罚性的原则。本来百度就要去获得别人的授权，比如说我给别人的授权就是一个很公平合理的价格，那我百度就会要拿出一笔钱，就是要支付版权费的，跟谷歌事先要拿出了一笔钱，准备等着付版权费和准备被罚是一样的。那么，但是如果你法院说在知识产权强保护的背景下，还要惩罚性的赔偿，说你明明知道这些都是有作品都有保护的，为什么你们还要拿过来去学习呢？比如说我们中国的这些各大的一个科学期刊、和谐期刊，你是不是都要去学一下呢？这些著作你是不是都要收集进来呢？你明知道，所以呢，明知你还去故犯，那可能就要惩罚性赔偿。那这个时候，它的这个人工智能产品，它的开发的成本 著作权的成本就特别高，所以我们认为在司法这个层面上，应该让法院给出这些这个侵权的案件当事人给他一个很宽松的、合理的这样的一个责任，会是一个目前的一个权益解决方法。我当然自己也写了一点东西，也写了一些提案，希望能够在诸多个领域里边能够去共同推进，让它的这个授权合法性呢就变得这个成本低一些。但是呢，我们要排除那些恶意的，排除那些故意的去侵权的那样的一些行为。所以最后呢，还要落实到企业的自律。所以上半场不是都在去讲那个审查、那个备案吗？其实它的功能是什么？让你自己承诺，我是一个守法的企业，是对你的一种自律，是在以后执法阶段的时候，衡量你有没有恶意，衡量你没有欺诈行为的一个依据。所以备案和这个审查，它其实有这样的一个作用。
加一点
也可以加，对，
就是涉及到刚才说司法认定哈，其实我当时说完说要靠法院，但我们也知道从实务的角度观点，在中国通过法院这块难度主要是因为我们现在的没有证据开示制度，就是实际上我们不知道这个企业它用的是什么样的东西去训练它的，你也很难真的去发现，对吧？这在美国有 discovery 会不一样在中国这点其实是蛮大的一个困难，是不是？将来如果真是有这样块的诉讼的话，其实可能会特别的要求法院得特别主动，或要求原告得比较有创造性的提供初步的这个证据，然后请求法院去再主动去做调查。所以对于作为这个事情的企业们，如果你是做训练的企业的话，你得确实得守口如瓶，你到底怎么做的？这可能是将来一个蛮大的一个事情。另外一个就是稍微学术一点，我最近听到国内最有意思的一个观点是，涉及到合理使用的，我不知道张老师怎么看？就有人说，哎，我们能不能把这个生成式 AI 的服务把它拟人化？说你如果把它当成人的话，某种意义上讲，哎，你就可以套用这个合理使用，对吧？为个人研究、学习、欣赏目的而使用作品。哎，我觉得这个挺有意思的，脑洞比较大啊，补充一下。
非常非常好，我特别喜欢看到你们之间的这个思想的火花。Okay, let me bring out Terry. I don't know whether the simultaneous translation is okay. No, in the US, we already talked about earlier this morning. There have been not much going on with regard to generative AI, but with the exception of a lot of plaintiff litigation, and the vast majority of them relate to IP violations. I think there are at least 10 or 11 ongoing, but people in the US have been telling me they probably all fell. I mean, maybe one or two may succeed. There was a recent case where, you know, the judge dismissed most of the claims, but only upheld one. Is it a stable diffusion case or something? I was like, Mark Lemley was advising the farm. So I'm curious about, you know, first, can you tell us a bit about these legal developments in the States, and what are your thoughts on this litigation? How likely are they going to prevail in court? Are we going to see the court, you know, being very liberal, or is it like the Chinese, very supportive of the industry? You know, what are your thoughts on this?
Well, by way of background, sure. By way of background, for the time being, the US is ahead of China in the development of generative AI. Now, I hasten to point out that generative AI, we're concerned with here, is only one form of artificial intelligence, and may well be that China is ahead of the United States in other dimensions. But with respect to systems that produce text, images, music, and so forth, the US is roughly a year, maybe a year and a half ahead of China, which is a long time in the development of AI. One of the reasons why the US is ahead is because of the brazen way in which the leaders have been training enormous systems on massive databases that, although they often conceal the identities of the specific works, it's reasonably clear a very large percentage of the materials they've employed are subject to copyright protection. So, in contrast to ironically, some of the Chinese leaders who seem to be more respectful of the copyrights. This state of affairs has indeed produced, as you suggest, a wave of litigation. None of the cases to date have resulted in final judgment, so we don't have an authoritative response. But if it would be useful, I can review for you the principal claims and what I think is likely to be the outcome of each strand. So there are three arguments made in most of the cases. The strongest of the arguments is that the use of copyrighted materials to train the models constitutes infringement at the input stage. Now, the principal defense asserted by OpenAI and other companies is that use of the data to train the models constitutes a non-expressive use and therefore falls within the fair use exception of US copyright law. And there's some significant case law that supports this proposition, the Original Authors Guild case, the Sega case, and so forth. So the basic notion here is that copyright law in the United States contains a judicially created safe harbor for relying on copyrighted materials to learn. Now, that is, although a strong argument, is not certain to prevail, because unlike the precedents that established it, the ultimate outcome of generative AI models are media that do enter into competition with the kinds of materials on which the models are being trained. In that respect, it's different from data mining in the traditional sense. So a nuance lurking here is whether the activity of using the copyrighted materials for training purposes is going to be considered non-commercial or commercial. And that in turn depends whether you focus on the intermediate stage of learning or on the ultimate outcome of charging customers, not resolved. So this, as I say, is the strongest of the arguments advanced. I think for the reasons I'll suggest in a minute, it will ultimately likely fail, but it is the most formidable of the attacks. The second of the three can be disposed of quickly. Several of the plaintiffs assert that the models themselves constitute derivative works of the materials that are input. This is a radical argument insofar as the remedy, if this succeeds, would be destruction of the models as infringing works. That's not going to happen for both practical and doctrinal reasons. The third and last of the claims is assertions that the outputs, the images or text that issue from usage of the models, are infringing. So there's a broad version of this argument, and the broad version is that all of the outputs constitute derivative works. That's likely to fail for the same reason that the corresponding argument about the inputs is likely to fail. There's a narrow version that has more colorable. So given by way of example, if the image produced by a image generating AI very closely resembles one already in existence to which someone else has a copyright claim, then traditional standards of substantial similarity may well give rise to liability. So that's unlikely to happen often, but that's a strong case in the circumstances in which it comes up.
I think this is a very good overview. So if you place the bet, how likely any of the, would there be one or two cases ultimately might prevail in court? I mean, the current cases that you see pending?
Well, as you undoubtedly know, in the US system, all of these issues are going to end up being resolved by courts of appeals rather than the trial courts. So the judgments of the trial courts are just intermediate steps in the process. And the courts of appeals traditionally take ballpark 2 to 3 years after final judgment in the trial courts. That means decisions on these issues are not likely to become evident for approximately 4 years from now. That's a long way into the future.
That includes the Supreme Court.
No,
Is it?
it
Not
does
yet. Okay.
No, so if the Supreme Court took it up, it would be another 2 to 3 years.
Okay.
By way of example, the strongest historical precedent for evaluation of a breakthrough technology was the treatment of the VCR in the 1980s, and that took 8 or 9 years to be resolved. So 4 to 5 years or 8 to 9 years down the road is a very long time. And so you ask about a prediction. By then, I think it is quite likely that these generative AI models will be sufficiently deeply embedded into the culture of the United States and maybe the world that the courts will not invalidate them. They will push aside the copyright claims. In much the same way in the VCR context, by the time the case finds, this is the Betamax case, by the time it finally reached the Supreme Court, 3 United States Supreme Court justices owned VCRs. And not surprisingly, the degree to which the technology was embedded in practice produced fairly, but a decision declaring that activity to be fair. I think the same thing is likely to occur with respect to generative AI.
It's fascinating. So the litigation process, the way the institution design in the United States in itself, is conducive to innovation, and then benefit these big companies.
Yes.
Yeah. So let me bring out Winnie. What's your thoughts on, these current issues facing, IP issues facing, generative AI and, particularly, one of the points that Terry mentioned is like, what if, the content that was generated is very, very similar to the input, but the chance is very small, I guess, right? I mean, maybe, unless you put in specific prompts that I want, can you write in a style, can you write Harry Potter, right? I mean, like J.K. Rowling, that probably would generate something very closely similar, but I would imagine the probability is very low. And I know Microsoft is a very big player in this respect. So, I would love to hear your thoughts on this. And also, have you guys run into any practical problems in practice?
Thanks for that question. And, really pleased to be joining this panel on a very challenging topic. I guess, as Zhang 老师 mentioned just now, and, Terry and Jing also mentioned, I think this is an area where the law is really still developing. There are different views about how we should balance the protection of IP rights of the copyright owners, and also, at the same time, support the advancement of the technology. Because as Terry was saying, this technology is going so fast, right? ChatGPT is only really commercialized in less than a year's time. And already here we are, right? Talking about all the possibilities, all the new potential that we are seeing. So, I guess I won't embarrass myself. You have a lot of, experts on copyright in this room and on this panel. I guess what I'll share is, how, as an industry player offering this service, how we look at the issue on copyright. First, I think it's very clear that Microsoft, as a company, we definitely respect IP. It's sort of a crown jewel of, how we run our business. So it's very sensitive to, how this issue is raising a lot of concerns by right owners. And clearly, there needs to be more discussions and debate in the society as to how we protect the rights of the different stakeholders. But at the same time, we do want to, bring this technology to our users as soon as possible. And, for Microsoft, we take the position that, we are compliant with copyright protection for offering our products and services. And we are willing to stand by our products and services. So Zhang 老师, she mentioned earlier that, we are offering this, what we call the customer copyright commitment to all our enterprise users, our paid customers. And, it's a duty to defend our customers, if and when they are being, if they receive the claim that, their rights have been infringed. And this is just, how we feel that we should be sharing the responsibility with our customers as they use our products. And, it's not just insurance policy, right? We have done our homework. We have implemented responsible AI by design for the last 6-7 years. And we have been learning a lot of experience from that. And also we have built in additional safety mechanisms, mitigation steps in our services to support us in making this commitment to our customers. So, how we see it is that it's really a shared responsibility. We do our part in, how we design our service, how we provide our products in a way that we feel is compliant. But then we also expect our customers to, fulfill certain conditions, like one, they don't, remove or circumvent the safety mechanisms that we put in. They won't, use anything which is obviously or the reasonable man, they will know that it's infringing, right? So your example, if you asked Gen AI to come up with a Harry Potter excerpt and then just distribute it, knowing it's protected, right? So we can't, control that, and the customer will have to be responsible. And then there's also the right to use the input data, because the outcome that is coming from generative AI is sort of a combination of the trained model information and also the input. So we really see it as a case of shared responsibility. And, we hope that, with this commitment to our customers, it will give them a peace of mind that, if they come across an allegation of infringement, we'll be there to, solve the problems together with the customers. I'll pause here first.
I'm pretty sure that under Winnie's hands, you guys did a great job. But if I remember correctly, correct me if I'm wrong, I'm not following IP litigation too well. Microsoft was challenged in the US as well for IP violation for this as well, right? I don't know whether you're familiar with that case.
I am not, but I won't be surprised either, right? Because as I said, this is an area which is fast developing. And I think it's good that we have this discussion, we have this, litigation, because that's how we, learn from, the process of what will be the right model to offer these services to the community.
Right.
Yeah.
And you guys are going to win anyway. So 我们回到张平老师刚才我们谈到了侵权，但是另外一个您刚才已经提到的一个很重要的问题，就是说生成式的这个人工智能，它那个创造的这个 output， 对吧？这个生成的内容是不是受到版权的这个保护？因为我们原来有这个所谓的思想和表达这个二分法，也就是说思想如果我的了解是对的话，思想是不受版权保护的，表达是受版权保护的。但是你在生成式人工智能出现了之后呢，你好像把这个东西给颠倒了，对吧？您能不能跟我们讲一下这方面的挑战？
对，在著作权保护的过程当中，两个最关键的问题，一个是作品，一个是作者。那么大家呢都在去 focus 这两个问题去讨论，说到底它的生成物有没有作品性啊？然后它的作者是谁呀？但实际上呢，我自己的观点，我一直都认为，生成式人工智能对著作权法的挑战不在于确权，也不在于你这个署名是属谁。包括像美国版权局刚刚这几天，他们又驳回一个登记，就是说不承认生成式的这个生成物是有作品性的。但我认为说，它对著作权法的最大的挑战呢，是说挑战了我们之前一直墨守成规认可的思想与表达两分法。因为我们以前人类自然人的学习呢，就是说你可以学习别人的思想，可以学习别人的风格，但是你完成的表达是另外一个表达。那么尽管跟他的风格很接近呢，那也是你独立完成的，所以它叫独创性或叫原创性。说只要你是你独立完成的，就认可你的劳动，你就享有这个作品的这个著作权。但是呢，我们看到也有另外一类的这个问题哈，比如说你临摹，你师从某一个大师，你一生只是学他的一种风格，最后你可以做到以假乱真了，就是你可以把大师的画作模仿的给 这世人一看，以为是出自于大师之手，但其实是你是临摹的。那么在这个时候呢，著作权法要求你署名谁谁谁临或谁谁摹，这样不会认为你是侵权。当然，中国在著作权法的第一稿的时候，就刚刚颁布的第一部法律的时候，他是把临摹当成复制了。后来有人说临摹不是复制哈，临摹是一种学习，是一个很高境界的学习，而且是水平更高超的学习哈。但是你要注明出处，你说你是临，这样呢就不会构成混淆。所以最后著作权的侵权呢，它还有一个混淆的一个判定。那么生成式人工智能呢，它就跟我们传统的这种临摹，它的过程啊完全变短了，变得非常快，非常容易了。我们以前要去学习某一个人的风格，可能你要学一生，什么程派呀、严派呀，就我们那些京剧的风格，还有我们什么这个画作里边，像齐白石的虾呀、张大千的马呀，你要学一生，你才能画出很神似的哈。但现在人工智能呢，它学习的特别快，它可能瞬间。他可能就是很快就把某一个作家的风格就全部都学到了，然后他又创作出了一幅画，跟他的任何一幅画作都不一样。但是他拿到这幅画去到版权交易市场去卖的时候，他如果不去署名，他会卖得很高的价格。很多人可能不知道真假，是不是齐白石又画了一只虾？张大千，是不是又徐悲鸿是不是又画了那个一匹马？不是以前我们都拿的是8匹马的画作，但是呢，他生前从来没有画过这个，所以我们看到呢，生成式人工智能呢，它趋近于别人的风格，趋近于别人的思想，然后最后做出完全不同的、不一样一模一样的表达，它构不构成侵权啊？叫不叫侵权？那么在中国的著作权法的这个抄袭啊、剽窃里边，其中就有这样的。就是以前我们说，如果你2个不同的表达，可能就不认为侵权。但自从那个琼瑶和于正的那个案子出来以后，然后我们的法院就认为，可能故事的情节都不一样，人物的名称都不一样，桥段呢也不太一样，但是那个脉络、那个逻辑、那个框架就很像，所以呢也认定是抄袭。那如果是这样的话呢，生成式的人工智能，它如果去模仿别人的话，或模仿别人的字，或者模仿别人的音乐，因为现在音乐也有风格嘛，那你就会很容易规避侵权，或者我不一样，或者是说全部都是侵权的就是按照我们说的，如果你的这个风格是受保护，你就应该那生成式的人工智能模仿的都是人类的风格，所以它的学习的能力极强的情况之下，它挑战我们日后在用这一类的工具完成出来的这个生成物，在进入到版权保护阶段的时候，它认定抄袭和剽窃的标准，这是一个最大的挑战。
对对对，非常好。然后我再问一下 Winnie let me come back to Winnie again. I mean, and the other important question is whether the output that's generated could enjoy copyright, right? I mean, if it can have copyright, who is entitled to the right, right? I mean, is it the users, the end users, or foundation model developer or the service provider? Let me just give a concrete example, like in the OpenAI, ChatGPT case, right? I mean, is there a licensing agreement between OpenAI and the users who should be entitled to the copyright? So what are your thoughts on this?
Yeah, that's a good question. I guess, from Microsoft's perspective, right? As we provide the generative AI services to our customers through Copilot or through Azure OpenAI, we do not claim any copyright in the output, right? But at the same time, whether our customer can claim copyright in the output, this is something that the customer has to decide as well, right? Because if you think about it, we may provide using the example that Zhang Laoshi just gave, right? We may be the instructions, the input may be to, come up with a drawing or an article that follows a certain style. And right now, copyright doesn't prevent you from following or copying a concept. It's really the expressive work that is being protected, right? So, but in the future, if the law is changed in the way that Zhang Laoshi explained, then, maybe that's something that could be a problem as well. So the customer themselves would have to decide whether they could just freely use or, distribute such work. And so, this is how we position the ownership point.
Right. I remember there's some US firms like Getty Image. They have created their own services for generating art. And then they were able to license the copyrights to users because they use their own copyrighted materials to train their model. So it seems like different companies have different policies. But those services, like the example like Getty Image, they make users feel comfortable in the sense that they know the end product will enjoy some sort of copyrights in a way, right? I mean, unlike ChatGPT, which that might be infringement problems.
I guess from in the example that you gave, right? Getty Images, if they already have their own library of copyrighted materials and they have ownership on that, they can fine tune the foundational model, right? And that allows them to have greater confidence to claim that they have copyright in the output, even with the support of generative AI. And I think this is how we look at the issue as well, and why the customer has to make the final decision. Because even if you get a human to a staff, right, in the company to create something or write something, at the end of the day, whether there has been any copying or infringement involved, the manager or the person in charge will have to still do the review. And this is also why we keep calling our products or services a co-pilot, because we feel that it's important that, we have human intervention when you're using our services. I don't think we're at the stage now where you can just allow Gen AI to make all decisions and, do everything for you. We hope that co-pilot is there to do things with you.
Right. Very fascinating. Terry, let me come to you about the copyright issues in relation to those output generated by AI. In the US, there have been at least 3 cases where the Copyright Office have denied the copyrights of AI generated image. And there was one case where the authors actually tried over 600 prompts and won an award in an art show, but still got denied for copyrights by the Copyright Office. And I believe there might be cases also in the court holding similar positions. So what are your thoughts on this? Do you think that, AI generated content could potentially enjoy copyrights?
You're right that in the United States, the position taken thus far by both the Copyright Office and the courts is that a work generated by AI does not enjoy copyright protection at all and falls into the public domain. That means that the second of the questions rightly identified by Professor Zhang never arises.
The true Professor Zhang.
The one to my far right. She suggested accurately that there are on the table 2 questions. One, is there any copyright protection for these works at all? And second, who owns it? And only if you answer the first question, yes, you get to the second one. And in the United States right now, currently, the answer to the first question is no. Indeed, 2 or 3 days ago, on December 11th, the Copyright Office Review Board issued yet another ruling reaffirming its position that, here's the quotation, if all of a work's traditional elements of authorship are generated by AI, the work lacks human authorship and the office will not register it, and applied that standard to deny copyright protection in a case in which the operator took his own photograph of a sunset and said, to a AI platform, alter this to resemble the style of Van Gogh's Starry Night. And the resulting composite work was denied copyright protection. So you asked the question, do I think this is a sensible position? No, I think it is a bad stance, both doctrinally and from a policy standpoint. And the position conversely taken by the Chinese courts is better. So with respect to doctrine, the reason why I think it's misguided, I'm going to do a little show and tell.
Oh. Is that how you usually teach at Harvard?
That's exactly how I teach at Harvard. Yeah.
You show the difference, you know, we don't bring camera into the classroom.
So the photograph, the image that I just created
Yeah.
and recorded on here.
Okay.
There's no question in the United States and in every other jurisdiction in the world, I own the copyright to it. Despite the fact that I set the camera for automatic on film speed, shutter speed, focus, depth of field. The only thing I did with the camera was choose vaguely a subject, meaning you. It did everything else. So this is, in my view, doctrinally precisely analogous to the way in which currently AGI, generative AI produces images. You insert a prompt, much like my holding the camera up, and the machine does everything else. So if, as I say, it's clear in every jurisdiction I own the image I just produced, then analogously as a doctrinal matter, the person who inserts the prompt into the generative AI program should own it.
Let me push back on this.
Okay, but I do want to come back to the policy issue.
Okay.
Let's stick with doctrine.
Well, I think there's still difference between using a camera and using generative AI, right? I mean, because using camera, you sort of know what you know, what you're creating, right? I mean, do you like, you know,
I just
you-
put it up here.
because you know, this is an image of what you see.
Yeah.
But with generative AI, you have no idea what you're gonna, you know, churn out. I mean, and by the way, the Copyright Office, there is a guidance opinion. I don't think the Copyright Office want to, you know, deny copyright in all cases, but they just emphasize that, you know, we want the human's inputs to be, you know, at the central of creating the art, right? I mean, but so far it seems to have a very high standard.
If we had a display here, I could show you the images of the most recent decision. And it's quite clear that the plaintiff in this particular case said, I have a photograph and I want you, the program, to alter it to more closely resemble Van Gogh. So there is at least as much direction inserted there as I provided when I did this. Nevertheless, copyright protection was denied. So here's the policy issue, which actually may draw us into an issue, onto a subject that, for which there would be useful conversation. The policy issue is that going forward, it will be crucial that the process by which any given image or piece of text is generated is visible to the world at large. Why? Well, because people have been demonstrated through behavior and through psychological studies, a deep need for being given credit where credit is due. Attribution turns out in the artistic context to be extremely important. And from the consumer side, knowing whether an image or a piece of text has been produced with or without the benefit of generative AI is crucial to consumers' decision-making. Do I want to purchase that photograph hanging on the wall? It will matter to me how it was created. And so accurate labeling of outputs is essential to the future of this field. And if you create a doctrine, as the United States thus far has, that denies copyright protection to partially artificially generated images, what it will produce as a consistent matter is falsification of the processes when people apply for registration. It will put pressure on people who use this technology to mislead. And that's exactly the opposite of what we want to encourage.
We're running out of time, otherwise I will continue with my debate. But I know Professor Zhang is your intellectual soulmate. I think you agree with him wholeheartedly, right? I mean, okay. But I disagree with you. So let me come back to 何晶啊。今年我们刚才已经提到了11月的时候北京互联网法院就是出了第一个案件这还是挺轰动的。因为在别的国家，包括美国在欧洲，我们还没有看到有任何一个法院是认可生成式的这个产品的这个内容的这个知识产权。对吧？我们是第一个判出来就是认可的您怎么看待这个案件？然后呢，那个案件还有一个比较受争议的，就是在那个案件里面，法官是判了最终的用户获得这个知识产权，对吧？但其实这块其实也是比较的争议比较大的，对这块你也讲一下。
对，我先把这个案子简单讲一下然后谈谈我们的想法。其实我们其实是蛮震惊的这个事情，就是就像刚才 Terry 所做了个演示，就是用照相机做一个演示，对吧？人拿照相机做创作，我们现在在全世界基本上都认定这是一个作品。那在这个案子当中，它是一个这个用户用这个叫 Stable Fusion， 就是等于应该是个开源的这个人工智能大模型。他给他设了很多的所谓参数，我待会儿给你们念一念这个参数是什么，然后制作了一个女生的一个形象，一点日式的女生形象。那法院最后就认定说2点，一个说他是用了大量的这个参数，有他自己的智力劳动做出了这种独创性的这种贡献，然后通过 AI 利用 AI 制作这个东西，能够有这样的一个东西出来，然后认定它是一个作品。这最核心的东西，本质就是像 Terry 所讲的，我认为这个作者使用者用了很多的参数，有它的独创性，还做一些调整，这是最关键的。我给你们大家念一念这个参数这个参数它的独创性是什么？念一部分，比如说先开始在讲超高帧照片、超逼真照片1:3，超高品质、高细节的原始图像数据处理格式，外景、日本偶像。高度细节对称且迷人的脸，棱角匀称的脸，均匀红褐色的辫子，柯达黄金肖像100.35毫米镜头佳能50f1.2镜头光晕黄金时间等等等等等等。OK， 这是一系列参数，还有反向提示词，大家都知道 prompt 反向的那个，我看中文是什么翻译的，那个不要有它就排除不要有糟糕的手，不要有糟糕的解剖结构，不要有缺失的手指，不要有水印，不要有多余的数字，不要有更少的数字，大概一大段。不要毁损，然后后面他还做了一个调整。我们中国的法官，这个法官叫北京互联网法院的法官朱格法官，那个我们曾经以前一起研讨过。我自己个人的一个分析是这样的这个判决我们非常感慨几点吧，一个是我自己做过一个案子，在中国法院，我们大概用了5到6年，最后说服中国的法院，甚至说服我们著作权法做了个修改。就是体育直播赛事节目 NBA 的直播赛事的那些画面是作品，花了我们5到6年向我们中国的法院证明，而且前头是屡败屡战，最后我们翻过来了。当时我们一个很核心的观点，就像刚才 Terry 所演示的，对吧？这么拍，有很多镜头 NBA 的多少个摄像头同时拍做制作，很多独创性。但中国有一些非常著名的法官认为这个不算，他认为任何一个人都可以指挥，这就可以了，这都可以很容易做到，而且这种独创性的高低说这个不算在那个背景里头后来当我们把它翻过来了，中国著作权认定这是视像作品 audiovisual art audiovisual works。 然后你再看这个案子里头非常有意思，我们的法官至少我自己个人觉得这个参数是太宽容了，看到这些参数说这种图像认定是作品，这是非常宽容的做法，但基本上是当成照片的照相机的这样一个类比。而且我私下里头认为，在这个案子当中，其实是比对着美国著作那个版权局的一个认定标准，只不过我们反过来，在美国版权局当中，他们拒绝了，就是当时最有名的一个案子，就是那个就大家知道那个女生的一个照片。就是用 Midjourney 所生成的照片，那个 Kashtanova 做的东西。当时美国版权局2个主要的一个观点说，你用这个 Midjourney 做出这些东西是 unpredictable， 是不可预测的，这是不可预测的一个方式。 另外呢，你做的那些 prompt，Mid Journey 做的 prompt，更多像是一个 suggestion， 像是个提示，而不是一个那样子的指令 instruction 怎么做。所以版权局有2个这样的一个 test， 这至少是一个 argument。我们中国的这个原告很聪明，我们一直其实到现在都怀疑这个原告是什么人，直接是个高手，绝对是个高手。基本上他向法院证明说，你把这些参数主要是这样子，哪怕调一点，一定还是出现那个小女生的样子，非常可预见性，这是不会变的。而且你看参数好像显得特别科学，至少是几十个词，而且还排除另外几十个词，所以他觉得大概100来个词加起来，更像是我们中国法院觉得这是一个比较有独创性的指令，然后有独创性的创作、智力劳动，最后组成了这样一个方式方法，认定是一个可以保护的这样一个作品，而且是人有的，他认为这是人创作的，人通过 AI 来创的，这个逻辑其实非常清楚的。但对比起来，跟之前中国法院的这个，我们在之前的一些法院的这种最著名的一些法院呢所见到的这个做事的方法是不一样的。所以介绍完这个案子一个分析啊，我再补充一点，其实也是回应 Terry 刚才做的这样一个分析，包括张老师，我们当时在做 NBA 的这个案子的时候，我们当时也很困惑，就是我们想搞清楚到底是怎么回事情。后来我们跟英国的一个大法官 Judge Burrs 有过一个探讨，大家都知道版权法来自于英国人，对吧？来自于英国，不是来自于法国，不是来自于美国。Copyright。后来到了大陆法系叫著作权法，著作权法和版权法一直在中国是有争论的，这个名字都是有争论的。Copy 其实就是 copy，OK。后来英国大法跟我们讲，他说告诉你为什么我们会给照相机拍的东西也会给它 copyright， 为什么给画画也给 copyright？ 这显然是2种不同的创作。他说我认为哈，这也许他个人的，至少是个英国大法官。他说我们很世俗，他说我们为了保护资本家的创作的投资，如果是拍电影也好，什么之类的，他哪会用机器拍的？他有投资投入，所以我们给他一个 copyright， 但它保护范围很窄，你得是一模一样的照片你才侵权，对吧？我这是拍了这些东西，我哪怕有版权，其实没意义嘛。我同样另外一个人在这也拍的话，同样也不会侵你的权，对吧？没人会说你拍这个照片有真的能有排他权。所以，但是真正的创作出来的东西，它保护范围会大很多。它真正创作出来的保护范围大很多。所以他说，这是我们英国人的一些想法，解释什么叫 copy， 和大陆法系的著作权法不一样。所以回到这里来，也许 AI 将来我们保护这些，是为了还是保护大家的投资、钱的创作，然后给它容易一点。我就是这么多。
Terry, what do you think of the Chinese case? Do you think that the Chinese court make a more sensible decision than the U.S. Copyright Office? Would you be worried? I mean, you mentioned the policy reasons why you would think it makes sense to endorse copyrights of AI generative art. But what about the long term? I mean, if everybody is doing this, taking the convenience of AI, and no one will be interested in investing, it's all human input in creating. Would we worry about, the decline of human investment in creating art and content?
I think it varies substantially by field of creativity. That if, to return to my earlier point, the wide variety of works generated 10 years from now are properly labeled, and so that consumers are able to pick and choose among them, then there will remain in many fields of art a substantial percentage of consumers who insist upon getting human-generated works. I myself, for example, I don't think I would purchase and hang on my wall a painting generated by ChatGPT. I prefer to support artists and to know the provenance of the work that comes to me. And I think that will be true with respect to novels. It will be true with respect even to photographs for a long time. There are other fields, however, in which there's a much more serious risk, and that includes journalism. So increasingly now, journalism throughout the world is collapsing because its business model has been corroded. And if Bing, relying in part upon ChatGPT technology becomes an increasingly sophisticated and reliable way of delivering to users information about what's going on in the world, then the willingness and ability of consumers to pay for access to the New York Times or to local journalism and so forth will continue to decline. And that will be catastrophic from the standpoint of providing the world at large accurate information necessary for democratic decision-making. So the problem that you identify strikes me as salient in some fields, like journalism, and not particularly salient in others.
So it's context specific.
Exactly.
Okay, very good. So we're running out of time, but I really want to get to this question. I want to ask Winnie about it. We spend a lot of time, like almost an hour, over an hour on copyright. But regard to IP, there's not just copyright issue. There's also trademark and patent. That's patent law that we might run into problems. Can you tell us a bit about the development in this area? Have you guys run into any problems in this area so far?
Yeah, unfortunately, that's not my area of specialty. I'm sure a lot of my colleagues at the headquarters are working on it. But, just to supplement what I was saying earlier about the copyright commitment that we give to our customers, is not just on copyright. The scope of our commitment and the duty to defend actually covers other type of IPR, including patents, trademarks, right of publicity, and confidentiality, and so on and so forth. So, but we call it copyright commitment because obviously that's I think the focus of discussion right now.
Right.
Yeah.
Fascinating. Okay, so we have a little bit time for our enthusiastic. Professor Zhang would like to chime in.
我有一点补充啊，
好
就是针对前边的几位发言人哈。首先第一点说，美国目前好像没有这类的案件，是吧？完了，中国呢是做了一个这个案子，但是呢有这样的事实，比如说微软的小冰这个机器人，他创作的诗集，这个大家都知道吧？已经出版了一本书，在这本书的封面上写的就是小冰注。那小冰就是一个机器人，要写的小冰注，但是微软的创作团队他们另外有一个版权的声明，他说这本书的著作权是归微软的创作团队，所以他在书的版权页上写的是微软创作团队拥有的那个圈 C， 就是那个 copyright，所以这个就是非常能够清楚的说明，他是承认机器可以进行创作，机器创作的东西是作品，但是呢，它的著作权呢是归这个创作团队的，所以呢，我认为没有法院的判决，大家都公认。而美国的版权局，他驳回了一些作品的登记。他为什么驳回呢？是因为那个登记的那个人自己说这个东西不是我做的，是机器做的。然后呢，美国版权局才又把它撤回来。实际上，如果他不说这个东西，就完全就是一个作品的样态。所以呢，这个版权登记机关他也不知道我怎么能给他剔除出去。所以鉴于这样的一种情况哈，我自己曾经讲课的时候，我今天没有拿到那个演示，我有大量的素材，大量的机器自动生成的音乐的、图形的，然后呢这个是这个摄影的，然后呢是文字的，都是自动生成，你根本自然人是区别不出来它是不是作品的，只能是说我们就按客观标准，就是它是不是具有独创性，是不是有美感，是不是有这种市场。那么至于它是机器完成的还是自然人完成的，我认为现在已经不重要了。有一个歌词写的不是吗？不管你见与不见，我就在这里，是吧？这个著作权，这个生成式的人工智能的生成物，说你不管你们人类或你这个政府部门或你这个法律，你承不承认它有作品性，它已经就在那里，它已经在版权的拍卖市场里边拍出巨额的价钱了。谷歌的那幅图片都已经1600万美元了。所以我们说，既然版权市场有这样的一个现状事实，我们为什么一定说不承认它呢？那么，但是承认它的时候呢，就出现一个法理上的问题，就说你给机器人视为一个作者，他是不是有人身权了，有人格权了？其实不是这样的。我自己的观点当然也是借用了美国波斯纳法官的一个观点哈，他在好多年前就说，著作权里边那个署名权。有的时候它不仅仅涉及到人身权和人格权的问题，它是一种来源的标识，标明这个作品是从哪来的，跟商标的这个作用是一样的。所以未来如果你是一个 自动的这个生成式人工智能创作出来的东西哈，你直接就标出来它来自于哪，然后呢，不要欺世盗名，说这是我人类自己创造的，这是人家机器创作的。但是它有没有著作权呢？它有著作权，它的著作权归谁啊？你可以归投资者，你可以归使用者，你可以归持有者，谁持有它，谁去干预它，谁用了它了，它就可以归谁。这就跟我们影视作品里边，他把那个著作权给了投资商，给了制片人，而没有给那个原创是一样的。所以我们已经在著作权法里边有了那种非自然人成为作者的、成为著作权人的这种现状，这种规则。为什么我们现在不承认这种生成式人工智能的这个生成物的东西呢？所以我就是想说这一点，我们其实不应该再掩耳盗铃，自欺欺人。然后我另外一个问题，就北护法院判的这个案例啊，它绝不是一个简单的一个，就是法官就这一时刻想起来说我要给他这样的，因为刚才何晶已经把那个过程讲过了。他可能会判理上会去说这么多干预，这么多选择，这么多参数是给了他一个创造性的一个劳动，给他了一个作者。但实际上这个案件不在于此，这个案件它在于它保护了一个产业，它未来这一类的案件会很多很多，它这是一种信号。而且呢，这个案件也不是说就简单法院就是自己在那去判，他在之前也征求了社会广泛的意见，他不光是在跟企业去调研，同时就专家学者不同的观点都针锋相对的观点他都调研过。我呢这个也是有幸跟他们参与了他们之前的这样的一些调研，所以我觉得法院是非常慎重的做出了这样一种判决啊，所以这就是我说明2点。
张老师，我听了您的这个评论之后啊，我现在觉得我有一个很大的遗憾，就是我在大学的时候没有上过您的课，抱歉，今天补课了，然后现在特别的遗憾，还想再回去听一次。好了，we are running out of time, and my assistant is going to blame me again, but I will still go ahead and ask for Q&A. Okay, under the risk. Okay, yes. Press the button. Introduce yourself.
Okay, thank you.
Short question. Okay.
Okay, thank you for this opportunity. My name is Yeung, a practicing lawyer in Beijing and also study in the HKU Law Master track.
Did you come from Beijing for this conference?
I come from Shenzhen.
Oh.
And before that from Beijing, yeah. I myself as a user of Stable Diffusion, so I happen to know a little bit about prompts. Actually, those prompts, as Professor Jing mentioned, a good portion of those are repeatable and reused and preset. You can see them on the internet. It's like, especially the negative ones, it's like shaking a candy box that you keep shaking until the candy is melted and a new flavor comes out. The creation of generative AI mostly relies on the randomness of the algorithm. So if we change a little bit of the prompts and the work turns out to be different, is that still generative AI, or they form the one-to-one relationship with the user, the plaintiff at the Beijing case? So that would be my question, and I would like to see your opinions, because that is against the principle of sweat on the forehead. My efforts is not enough to create creativity and uniqueness.
So that's why I think this case is quite suspicious, to be honest. When they say it's quite predictable, it's the same thing, I actually really doubt it. That's why. But the way why they want to protect this, I can understand, right? The one thing I was going to say that in the patent area, I know someone really, really passionate about using, granting inventorship for those drug invention contribute really mostly by generative AI inventions in order to protect the investments. So that area is another big box. And that's the policy argument is much stronger. For the copyright one, so lots of this for entertainment, to be honest, right? The damage is only 500 RMB. Okay.
Excellent. Wow, a lot of questions. Hao Chen, yeah?
I'll be very quick.
This is our law professor, IP law professor, Hao Chen.
Thank you. I teach IP here.
Yeah.
By the way, so I'll be very quick. I just want to quickly mention another Chinese court's ruling.
Earlier.
It was a few years ago by Nanshan District Court of Shenzhen, in which also rendered a decision about copyrightability of works generated by AI systems. So in that case, it's totally different from the Beijing Internet Court's ruling. In that case, it granted copyright protection to the developer of AI system, namely Tencent. So Tencent using their so-called dream writer, it's a writing bot, which created a piece of financial news article and published online, and but the defendant copied the article and republished it online. So Tencent sued the defendant for infringing its copyright. So the district court in Shenzhen, sided with Tencent, deciding that it is the Tencent team that designed the AI system, also control the creation process. So that's why copyright ownership should be granted to Tencent, and that piece of work, was recognized as a copyrightable work by satisfying the originality requirement. So this is also another case we need to bear in mind. Although in that case, I have to mention that the generative AI thing is a little bit thin. It's pretty much like a compilation of works, but that ruling actually gives us another approach to deal with the copyrightability of AI generated works.
Right. I mean, I'm so glad that you make that point. And remember, you wrote a piece. You were one of the earlier authors that actually you wrote the piece on the copyrightability of AI before the emergence of generative AI. Did that piece appear in Iowa Law Review? What's the name of the piece?
So basically, I disagree with all these rulings. I argue that we could protect copyrightability. It works generated by AI system, but we need to provide a lot lesser degree of copyright protection. I call it sui generis mechanism to protect such works. For example, we don't need to provide life of author plus 70 years is a term of protection for AI generated works. Instead, in the article I proposed, just 10 years or maybe less than 10 years. So this is one part of the proposal.
Right. Yeah. You're definitely. I think you are one of the very first few scholars who commented on this. So Hao Chen, kudos to your work. I think we saw another pair of hands. Yes. Last question. Okay.
Hello. My question relates to, again, copyrightability. Obviously, there are good policy reasons.
Would you introduce yourself?
My name is Hayden Lau. I'm a tech lawyer and I'm not an IP specialist. So from that angle, the IP specialists on the panel hopefully can clarify this point. Obvious policy reasons to protect copyright, generated from AI. But I also heard from Professor Zhang that the actual work might not be distinguishable, right, as between, output from AI or output from humans, right? On the other hand, I think, the sweat of the brow doctrines has been going out of, fashion probably since late 90s or early 90s. And for a human being, copyrightability requires only a modicum of creativity. Whereas we've been, I've heard lots about, sweat of the brow type of argument for AI generated work to be copyrightable. Now, given the actual work might not be distinguishable between AI and human outputs, right? Is that a good sort of doctrinal basis to govern, copyrightability going forward? And we also heard from this gentleman here about, perhaps a sui generis, a sort of one-off type of protection for a special type of work. But how can we realistically go forward with that sort of protection when the work itself, we can't tell apart whether, it's generated by human or AI to begin with? Thank you.
Sure. Let me try to link together these two last questions. As a doctrinal matter, the United States does not require creativity as an input. The European Union does, but the United States does not. And indeed, the accidental creation of an image, the classic example is a clap of thunder that causes a scribe to jerk his finger, will still generate a copyrightable image. So and now to try to tie this to Hao Chen's intervention, here's a slightly different analogy. When a lyricist and a composer combine to produce a musical, the copyright in the musical is held by both of them. They're joint authors, and they each have the right to credit and each have a right to exploit it. So unless and until we have a sui generis regime, which in truth is
The Hao Chen regime.
the Hao Chen regime, yes. Yeah. Until we have the Hao Chen regime, we might avail ourselves of this existing doctrine, which is joint authorship, which would allow acknowledgement both of the input of Tencent and of the person who's inserting the prompts, and then rely upon licenses of the sort that Microsoft is providing to ensure that ownership is appropriately concentrated. So Microsoft is, as you describe it, one of many companies now that by contract, by license, transfer whatever any interest they might have in any particular piece of output to the operator of the system. So if you create at the threshold a principle of joint authorship, which establishes appropriate attribution, and then rely on licenses, you will generate a workable regime without legislative reform.
Just one quick clarification. We don't transfer our rights because we never claim any rights. The way we see it is that the inputs and, it's really, and both the input and outputs are customer data, right? And so, we never have any rights in it, so we won't be transferring. It's the customer that is in control.
But I'm suggesting that you be given rights and then delegate.
You're
them.
very generous.
Talk to Brad Smith about this.
Okay.
Okay, so my assistant is going to give me that sentence for running vastly over time. Okay, but this topic is so fascinating that we will further explore it. Hao Chen is running a fantastic program on Saturday morning. So come to Hao Chen's conference, starting at 9 o'clock in the same room.
Oh, no.
9:30?
9:30 a.m. on Saturday.
Because Hao Chen's conference is very popular. So if you have to come early, and Bill, Harry is going to be the keynote. Yeah, so I really look forward to that one. I will also come. And so we can carry on our conversation on IP. So this ends, our third session on IP. And then our next session is on ethics compliance, starting in 20 minutes. So we come back at 4:15, okay? Thank you.